Good afternoon, ladies and gentlemen. Welcome to Hong Kong U. I am Jen, a faculty member, and I'm pleased to be chairing today's session. With us is no stranger to the law school and no stranger to Hong Kong, Professor Christopher Forsyth, the Emeritus Sir David Williams Chair at Cambridge. And today, he'll be presenting a paper which I had the privilege of getting a sneak preview in Singapore, and I believe is going to be very thoughtful, if not even provocative. As entitled, The Development of Classical Administrative Law and Modern Threats to It. I believe it's going to trigger some response, and before we get it, perhaps we could put our hands together and welcome Professor Forsyth.
Well, thank you very much indeed, Pujen. It's always a delight to be in Hong Kong and to be surrounded by some of my ex-students who I see a few in the audience, and I'm pleased to see them. This is intended to be a slightly provocative paper, Development of Classical Administrative Law and Modern Threats to It. Not, I think, provocative in the development of the classical administrative law, but views may very well differ on the threats, or what I perceive to be the threats to it, of which I'm only going to deal with two this afternoon. There are others. Is this better? After the Second World War, administrative law was definitely in the doldrums. There'd been a huge accretion of power to the state in the Second World War, and after the war the Attlee government came in, and it was a reforming government with lots of nationalisation of coal and steel and the establishment of the National Health Service. All of these involved the discretionary exercise of power, and it was widely assumed that that power was effectively uncontrolled. And very eminent people, Lord Devlin, the House of Lords judge, for example, thought that the common law had lost the power to control the executive. It was a very gloomy point of view. And that was the 1950s. There were sparks of light in some of the judgments of Lord Denning in the 1950s, but on the whole the picture was one of gloom and really a situation where the rule of law seemed to be threatened. But the judiciary responded, and in a series of scintillating and bold judgments, they changed and completely transformed the position. In two cases decided 50 years ago, Anisminic and Padfield, and one decided 54 years ago, Ridge and Baldwin, the foundations were laid for modern administrative law. And when you add into that mix the famous Wednesbury case from an earlier era, the conceptual foundations for modern administrative law were complete. The organizing principle was jurisdiction. Did the decision-maker act within or outside the decision-making power granted by Parliament? If the decision-maker was outside those powers, the decision was legally non-existent and void, and that had an important consequence. It was not caught by ouster clauses, which were reasonably interpreted as applying only to valid decisions. So an ouster clause that said no determination of such a body shall be called in question in any court of law was interpreted as meaning no valid decision would be unable to be challenged in a court of law. And an invalid decision, a void decision, wasn't caught by the ouster clause. This may be traced to Anisminic, but in fact it's much older. Once you had determined that the decision-maker had the power to act, do what he wished to do, the question was whether that decision was taken in a procedurally fair manner. The duty to act fairly now applies to practically anyone who decides practically anything. If a decision was not made fairly, it was once more invalid and void. And this can be traced with some hiccups to Ridge and Baldwin. Similarly, a statute under which the power arises grants the power for a particular purpose, express or implied. Every time Parliament grants a power, it does so subject to certain implied or expressed constraints. There's a purpose that Parliament has in mind in granting power, and that purpose is a limitation on the exercise of that power. So if he or she acts for some other purpose, they act invalidly and the decision is void. Since statutory power is always given for a purpose, it follows that there's no such thing as an unfettered discretion. All this is traced to Padfield. From these simple ideas, classic administrative law was constructed. Today it is the case, with very few exceptions, that any person or body exercising public power may be called to account to the law for its exercise. This was a great judicial achievement. Lord Diplock, in the passage that I cited earlier, attributes it to the judges. But it wasn't only the judges, it was an academic achievement brought forth from the writings of Professor Stanley de Smith and Sir William Wade, who chided, corrected, explained as the process went along. I might, for example, tell you the story of Sir William Wade in the case of Regent Baldwin, of which I imagine many of you are familiar with the case of Regent Baldwin, perhaps not so many with Sir William Wade's influence on it, although it's not acknowledged in the judgment. When Regent Baldwin was going to the House of Lords, counsel for the Chief Constable, Desmond Ackner, afterwards Lord Ackner, and a great House of Lords judge, realized that the case had been wrongly argued in the earlier courts, and cast about for help and found it with Sir William Wade. The case was to be heard in the House of Lords the next day, and Sir William Wade was due to go to the theatre with his wife. Much to the chagrin of his wife, he cancelled the theatre visit and spent the evening drawing up a paper for Desmond Ackner, setting out the classic natural justice authorities, explaining how the common law, going back for about 150 years from Regent Baldwin, had favoured the rules of natural justice and applied them to the exercise of statutory discretions, unless excluded by Parliament. And so he laid the foundations for Lord Ackner's submissions the following day, which were in the end successful, and Regent Baldwin established the primacy of natural justice as a principle of the common law. A crucial part of this story is the ultra vires doctrine. Don't be misled, of course, by the Latin. It simply means beyond power or beyond jurisdiction. And when Parliament is sovereign, as it is in the United Kingdom, and it's a very interesting question in Hong Kong, which I won't go on to now, where you don't have a sovereign Parliament, but you have a constitution, whether the locus of the justification for judicial review lies within the constitution or whether it lies impliedly from what Legco says, or whether it lies in the common law. That's a matter for debate on another occasion. When Parliament is sovereign, as it is in the United Kingdom, then the ultra vires doctrine, or something very like it, necessarily provides a justification for judicial review. And there needs to be a justification for judicial review, because what is the justification to take the stance of an officious bystander? What is the justification for an unelected official, such as a judge, to quash a decision made by an elected Minister of the Crown? A Minister of the Crown who's elected himself, a Minister of the Crown who's answerable for the exercise of his power to Parliament. What justifies the unelected official in saying that that decision made by the Minister is invalid? So that's why we need a justification. Professor Baxter, and it's no surprise that Professor Baxter is the author of the standard work on administrative law in South Africa, going back to the 1980s and the 1970s. In other words, difficult years in South Africa, who comes out with absolute clarity The self-justification of the ultra vires doctrine is that its application consists of nothing other than the application of the law itself and the law of Parliament to boot. If an official law acts beyond his power, then his act is legally non-existent and void. There's nothing exceptional about this, although it's very important, that a court should uphold the law and declare the act void. This is simply the rule of law at work. Now, life is more complicated than I've just presented it to you. Statutes are often silent or uncertain, and it's implausible to suppose that Parliament intends every nuance or point of detail that may arise in the application of a statute. But as Lord Steyn said in Pearson's case, Parliament does not legislate in a vacuum. Parliament legislates for a European liberal democracy founded on the principles and traditions of the common law. And the courts may approach legislation on this initial assumption, and this assumption only has a prima facie court force, may be displaced by a clear and specific provision to the contrary. This is the so-called modified ultra vires doctrine, in which it is presumed that Parliament, unless it makes its contrary intent clear, intends that power should be exercised in accordance with the principles of good administration. You see, there is a tension here. We have praised in the development of classical administrative law the creativity of the judges in these three decisions and the others that are so around them, Regent, Baldwin, Padfield, and Anisminic. The judges were creative in those judgments, and that is a good thing. But at the same time, that creativity has to be reconciled with the supremacy of Parliament. And if you take an absolute view of this, the supremacy of Parliament would preclude any creativity by the judges. So how is that creativity to be reconciled with the supremacy of Parliament? And it's done by the modified ultra vires doctrine, on the assumption that Parliament legislates for a European liberal democracy founded on the traditions and principles of the common law. So that's the space for judicial creativity. The judges, in developing the common law, are doing what Parliament intended. Parliament intends that creativity. But the ultra vires doctrine, even in this modified form, is not found convincing by all. Others, some very eminent, locate the justification for judicial review in the common law. That's in the UK context. In the Hong Kong context, it would presumably be within the basic law. The point that I would defend is that where Parliament is sovereign, something very like the modified ultra vires doctrine must be the justification for judicial review. And there's a certain logic to this that I'd like to run through just briefly. Suppose a decision maker complies with every requirement express and implied laid down by Parliament for the validity of their decision. There can be no extra requirement, no additional requirement added on, say that fuller reasons for the decision should be given, or that an oral hearing should be given, or whatever. If every requirement that Parliament has laid down expressly or impliedly is complied with, the common law cannot add on a requirement, or subtract a requirement, or modify a requirement, without challenging the power of Parliament to lay down the requirements of just validity. Somehow the creativity of the judiciary in developing in administrative law has to be reconciled with the supremacy of Parliament, and that's done through the modified ultra vires doctrine. And that's the reason why the logic I've just been through shows that any creativity challenges parliamentary sovereignty unless there is something like the modified ultra vires doctrine in force. But I won't go through the various people, some of which Pujan has seen me arguing with over many years over the ultra vires doctrine versus the common law. How is the reconciliation between the different schools of thought to be found to be so difficult? Behind the technical arguments is the fundamental question about the constitutional position of the judiciary. Are the judges, like everyone else, ultimately subject to the law, or are they the masters of the common law? In other words, do the judges stand above the law, free to develop it as they see fit? Or do they stand beneath the law, subject to it like everybody else? Surely the position is that the law is the judge's only master. In England, the judges swear an oath on taking office to do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. They swear to apply the laws and usages of this realm. They don't swear to apply the laws and usages of this realm and a few others we think about on the way. They are bound to apply the law as it is. There's a similar oath in Hong Kong in which the judge swears to serve the Hong Kong SAR conscientiously, dutifully, in full accord with the law, honestly and with integrity, safeguard the law and administer justice without fear or favour, self-interest and deceit. That's rather, if I may express an opinion, rather long-winded. But I think the heart of it there is still that the judges are bound by the law. The law, of course, needs to be developed to take account of changing needs. And fidelity to the law founded in the oath means that the changes that the judges introduce are interstitial and incremental and in accordance with recognised doctrine. And that means the challenge of the judicial office today is to adapt the law to the requirements of the present while staying within the overlapping constraints of the law and the Constitution. Sometimes, of course, the judge finds it frustrating to proceed incrementally when it's clear that justice requires an immediate and broad reform, and the legislature seems to be sitting on its hands and not doing it. But the creation of classical administrative law, extending the benison of the rule of law into practically all exercise of public power, is an eloquent demonstration of what can be achieved by the incremental approach. Now, if that is classical administrative law, with jurisdiction as its central concept, sovereignty of Parliament as a crucial part of the picture, at least in the UK, what are the threats to classical administrative law? And I will be express about what is implied by this. I'm arguing that the judges are straying beyond their proper constitutional role. And I'm going to give some examples of that. First of all is the Evans case, which I am going to argue is an example in which the Supreme Court paid lip service to the sovereignty of Parliament and in fact disregarded it. And it's a potentially dangerous decision because the courts are not going up front, as they said in the Jackson case, that there are circumstances in which we would challenge parliamentary sovereignty. They are saying we're not challenging parliamentary sovereignty, but then put in a meaning on the legislation that Parliament could never have intended and certainly didn't intend. Let's unpack those provocative statements a little. The case is about Prince Charles's black spider letters. Prince Charles's handwriting allegedly looks like a black spider. And he's renowned for writing letters on issues of public policy to ministers of the Crown, saying it's absolutely awful that there's this problem and nothing's been done about it, and what's the minister's view? Now, of course, Prince Charles could write letters to ministers of the Crown, and anybody else can write letters to ministers of the Crown, and they will, I suppose, usually get a courteous response, but nothing significant really happens. But a journalist, knowing that Prince Charles had written these black spider letters to ministers and continues to write these black spider letters to ministers, wanted to see what he said. He thought there was a dastardly plot. The journalist thought that there was behind the scenes an unelected monarch in waiting was influencing real political power by writing letters to ministers, and the people should be entitled to see what the letter said. Now, I should make it clear that I take no view on whether Prince Charles's black letters to ministers should have been disclosed or not. They have been disclosed, and they reveal nothing of consequence, it seems to me. They reveal that Prince Charles says in his letters to ministers very similar things to what he says in public speeches and addresses and so forth. He's very concerned about the environment and so forth. There's no smoking gun. There's no improper political influence or constitutional influence that one can see. But I take no view on whether, as a matter of law, they should have been released or whether they shouldn't. I'm just filling in the background for the case. And in Evans, we have an example of the Parliament clearly overriding, well, I should unpack it a bit more. In fact, I'll go on to the next slide. I'm afraid modern statutes tend to be rather dense and incomprehensible. And this is Section 53 of the Freedom of Information Act. A decision notice or enforcement notice to which this section applies shall cease to have effect, if not later than the 20th working day following the executive date. The accountable person, which is a Minister of the Crown, gives the Commissioner, that's the Commissioner of Information, who administers the Freedom of Information Act, a certificate signed by him stating that he is on reasonable grounds formed the opinion that in respect of one or more of the requests, there was no failure falling within Section 53, subsection 1b. What that means is that if a Minister of the Crown gives a certificate stating that he has on reasonable grounds formed the opinion there was no failure falling within subsection 1b, that is the section that requires disclosure. In other words, this is a veto. It allows the Minister of the Crown to veto the decision of the Information Commissioner that a certain piece of information that has been requested should not be disclosed. Now comes the crunch. Where did Section 53 come from? Well, it's all beautifully set out in Lord Wilson's dissent in Evans. And there he tells the story in that rather dense wodge of text that I've put in front of you, of how when the Freedom of Information Act was first introduced into the UK's Parliament, no one had a right to any freedom of expression. It was entirely a discretionary matter, so that the public authority of which information was requested had a discretion whether to disclose that information or not. And of course, they would be subject to judicial review if they breached any of the classic principles that we'd been looking at, if they didn't give a proper hearing, if they acted for an improper purpose, if they took an unreasonable decision, etc., etc. These would all be matters that could be subject to judicial review and in accordance with ordinary principles would be liable to be quashed. But when introduced, the Freedom of Information Act gave nobody a right to any piece of information. Everything was subject to the discretion of the public authority. After debate in Parliament, it was decided that instead of having a discretionary basis of freedom of information, it would be done on an entitlement basis. You would, if you fulfilled the requirements, be entitled to the information. So far, so good. But Parliament took the view that there were certain circumstances in which the public interest required that you shouldn't be entitled and that there should be a ministerial veto. And so the compromise that emerged from Parliament was that there would be entitlement under the Freedom of Information Act, but it would be subject to a veto. Now, that may have been a good thing or it may have been a bad thing. The crucial point is that Parliament clearly decided on a system where there was a veto. Whether that was a good thing or whether it was a bad thing is a matter for debate on a political occasion, not on a legal occasion. And that's all clearly set out in Lord Wilson's dissent. It's also important to note that what is at issue here is not a question of law, but a question of weighing up the public interest. It wasn't as whether, as a matter of law, the journalist was entitled to Prince Charles's letters. It was whether the public interest, whether the commissioner weighing up the public interest had rightly come to the conclusion that the balance of the public interest lay in disclosure, or whether it didn't. So it's not a question of law. Once more, Lord Wilson gets it spot on. As Lord Hoffman had said in the Auchenbury case, in a democratic country, decisions as to what the general interest requires are made by democratically elected bodies to persons accountable to them. Ministers have a legitimacy of their own, and the executive authorities are proper judges of the public interest and where the balance of the public interest lies. It's not as if the veto power was seeking to seize the power from the courts to say what the law is. Well, I, of course, have only presented you with the dissent, Lord Wilson's dissent, which is well worth a read. The majority, of course, took the view that the veto effectively had no role to play. It had a limited role to play if there'd been some fundamental change in the evidence since the original decision and the matter come into court. But the Supreme Court found it just offensive, really. I don't think that's too strong a word. They were much more polite than that. Thought it was offensive that a decision that an Attorney General or Minister of the Crown could overturn a decision that judicial authorities had reached, and said that they could think of no such example. There are several examples within the British Constitution, which I won't go into now, but it was a sense of horror and dismay that the idea that an executive authority could overrule a judicial authority. And again, the question might be that that is a very bad thing as a matter of principle, that executive authorities should not be able to overrule judicial authorities. But it's crystal clear that that's what Parliament provided for by Section 53. And if one accepts that as a matter of law we have a Supreme Parliament, then whether one likes the outcome or not, one has to accept as a matter of law that the executive veto could exist and could be effective. Here's Lord Neuberger on that question of public interest. Whereas here a court has conducted a full open hearing into the question whether, in the light of certain facts and competing arguments, the public interest favours disclosure of certain information, and has concluded for reasons given in its judgment that it does not, Section 53 cannot be invoked effectively to overrule that judgment, merely because a member of the executive, considering the same facts and arguments, takes a different view. So if the member of the executive takes a different view, he can't overrule the judicial authorities. And yet that is surely exactly what Parliament provided for in Section 53, that the ministerial veto could be effective. is Lord Neuberger not simply rewriting the statute to say what he would have liked Parliament to say, rather than what Parliament did in fact say? The government was pretty horrified by this, and I happen to know that there were quite well-developed plans to overturn Evans by legislation, because the question of the veto is particularly important in that if it's ineffective, it means that cabinet papers and the like are in principle subject to disclosure. Nobody really cares about Prince Charles's letters. I'm sure Prince Charles cares about the letters. But no one really cares about Prince Charles's letters, but they do care about whether cabinet documents, let's suppose the minutes of the cabinet meeting currently going on about whether missile strikes should be launched in Syria. It would be politically very embarrassing if the frank discussions of the cabinet on an issue of that kind could be revealed in a month or so's time after following a Freedom of Information request. So the government wanted there to be an effective veto for what seems to me good constitutional reasons. But it was not to be, because what happened? Brexit turned up and swept away everything. There are many good reforms that were on the stocks within the inner workings of the British government that, I'm sorry to say, have all been cast aside because of Brexit, because Brexit now dominates everything. So Evans was to be overturned, but it is not. But it is an example of paying lip service to parliamentary supremacy and in fact saying we don't like what Parliament has said and we're going to change it. Now, Cart versus the Upper Tribunal. I'm afraid the technicalities abound. This was a dispute over child maintenance. Mr. Cart had been ordered to pay a certain sum to Mrs. Cart by the Child Support Agency, and he appealed against this determination to the first-tier tribunal, who dismissed his appeal, and he appealed to the Upper Tribunal on 4 grounds which we're not really interested in. The Upper Tribunal refused leave to appeal on the 4th ground, and it was really the 4th ground that he really wanted to appeal on. So, Child Support Agency appealed to the first-tier tribunal, appealed from the first-tier tribunal to the Upper Tribunal, but the Upper Tribunal would only grant permission for the appeal on some of the grounds, not all of the grounds. So Cart was stymied, unless he could go beyond the Upper Tribunal. Now, there was a right of appeal on a point of law from the Upper Tribunal to the Court of Appeal, but he couldn't avail himself of that because the legislation very carefully excluded the granting or refusal of permission from such an appeal. If Cart was going to be able to do something, sorry, I'm being too soft again. If Cart was going to do anything, it was going to be by judicial review of the Upper Tribunal. There's no further appeal rights, just judicial review of the Upper Tribunal. Once more, there's an argument from parliamentary supremacy here. Parliament had quite clearly and thoughtfully decided that there were some decisions where there has to be an end to litigation, and if you've been able to appeal to the first-tier tribunal, and then the Upper Tribunal sees nothing at all in your application, perhaps that was far enough. Anyway, that's what happened. Cart's only possibility was the Upper Tribunal subject to judicial review. Now, there's a very good argument to say that the Upper Tribunal is not subject to judicial review. The first is that, as a matter of law, the Upper Tribunal is established as a superior court of record. And lots of people had thought, and there's some quite good authority for the view, that that means that you have the same status as the High Court, and the High Court, as everybody knows, is a court of unlimited jurisdiction, and therefore not subject to judicial review. But every court that heard the case, the High Court, the Court of Appeal, and then the Supreme Court, rejected this idea and held that the Upper Tribunal was subject to judicial review. It was not a court of unlimited jurisdiction and so not subject to judicial review. The Supreme Court accepted that the Upper Tribunal was subject to judicial review, but also said that there would be no return to the pre-Anisminic law. That's the law where you drew a distinction between jurisdictional errors of law and non-jurisdictional errors of law. There'd be no going back to a distinction between jurisdictional and non-jurisdictional errors of law, as the Court of Appeal had proposed, because that would lead us back to the distinction between jurisdictional and other errors, which was effectively abandoned in Anisminic. Instead, the court restricts the availability of judicial review on pragmatic but not principled grounds. The court, in Baroness Hale's judgment, makes a profoundly pragmatic case that permission to apply for judicial review of the Upper Tribunal should only be granted on the stringent second-tier appeal criteria. Second-tier appeal criteria are something that were produced like a rabbit out of the hat from a statutory background, and it's simply if some matter of public importance or fundamental principle arises. So the Supreme Court says that, having said the Upper Tribunal is subject to judicial review, it opens up an absolute explosion of judicial review, because every error then made by the Upper Tribunal would in principle be subject to judicial review. And if that were the case, the courts could be clogged with judicial reviews. So there has to be some control and influence, and it's controlled with the magic second-tier appeal criteria that permission to apply for judicial review of the Upper Tribunal would only be granted where that second-tier appeal criteria were satisfied. The Supreme Court thus, while establishing in principle the general availability of the Upper Tribunal, because all errors of law are now jurisdictional, as Anisminic teaches, has carved away so much of that principle that only rarely will judicial review lie against decisions of the Upper Tribunal. But what the Supreme Court is doing here, again, in a way, the question of whether this Upper Tribunal is subject to judicial review or not is an important question, but what is more disconcerting about it is that it comes about through the exercise of this pragmatic discretion. There's a clear distinction in the Supreme Court not to lay down clear rules that can be followed in the future by the lower courts and individuals seeking to guide their conduct. Instead, the outcome of legal disputes is made dependent upon the exercise of judicial discretion to the detriment of legal certainty. If the approach of CART is applied generally, and interestingly enough, it hasn't been applied generally since the 8 years or so that it's been around. If the approach of CART is applied generally, the question of whether a decision maker has power to make a particular decision, i.e. whether the decision is within jurisdiction, becomes a matter of discretion. In effect, law is replaced with judicial discretion, and classic administrative law disappears. Indeed, in CART, there is reference to judicial review having to be rational and proportionate, clear signals that the courts would decide whether judicial review was rational or proportionate. The courts are not being subject to the law, but are making it up as they go along. What of the future? I hope, wise enough not to make predictions. Everybody who's made predictions political predictions in the last couple of years has been proved wrong. But there are some possibilities. It may be that the UK government is so concerned with Brexit for decades to come that its plans that it originally had to reform human rights law and the application for judicial review come to naught. The current uneasy tension between the judiciary and the other branches of government continues indefinitely. I should make it clear that there is a tension between the judiciary and the executive, and there is also a tension within the judiciary, with some judges favouring more radical approaches and others less radical approaches. So there's tension between the judiciary, tension within the and the other branches of government, and tension within the judiciary. It may be that the judiciary, emboldened by a government distracted by Brexit, will assert itself more forcefully as the guardians of the Constitution and effectively can gain unchallenged control over the merits of major decisions. That's a possibility when you look at cases like Evans, where Parliament's clear and principled decision is just ignored. But on the other hand, you've got to have regard to the fact that in the Brexit judicial review, every one of the judges concerned upheld and supported the classic Dyson view of parliamentary supremacy without any hesitation. So there is tension, but it's not necessarily the case that the judges are rebelling. It may be that the government's response to the growth in judicial power is to make the appointment of the higher judiciary subject to parliamentary approval. The judiciary has become much more political. If it becomes much more political, as in the United States, and they trim their judgments to the political tide, some kind of parliamentary approval of judicial appointments seems inevitable. These are possible developments and no more than that. But they are possibilities that I generally deprecate. But if the judiciary are to make important political decisions, they must anticipate that the political processes will seek to hold them accountable. Thank you very much indeed.
Thank you, Professor Forsyth, for providing the majestic sweep of administrative law in the UK over the past century, perhaps, or at least over 50 years of it. Before I turn to the floor and take questions, perhaps I could, abuse my discretion or use my discretion as a chair to pose certain questions or to offer certain comments for everybody's consideration. And I think if I gather from Professor Forsyth's speech is that he has expressed certain circumspection about the English judiciary's somewhat recent activist turn, and he is somewhat regretful of this activist turn. And he would like us, or at least like the English judiciary, to return to its more classical roots. But we're just wondering, Anisminic, Wednesbury and reasonableness, all these were doctrines that were heretical once when they were first invented. So, what could be heresy today, like proportionality, might become ubiquitous in 5 to 10 years. And even if it's heretical, may I ask, perhaps has the ship sailed? Is it too late to turn back? And is there other ways of accommodating change without perceiving it as a classical threat? And interestingly, I don't think Professor Forsyth had time to flesh out all his arguments, because I've seen a version of it in Singapore where he also talked about proportionality in it, and he was talking about how the courts now are using proportionality to assess the reasonableness of the government's action. And I think in Hong Kong, most of us are aware of Hai Sen, the 2016 case, whereby the CFA has added one more step to the proportionality doctrine. And I think I find a bit puzzling, and since there are so many constitutional practitioners and scholars here, perhaps I could pose this question to all of you. And what puzzles me was actually paragraph 142, where the court said, in general terms, when the town planning board reaches decisions which are not flawed on traditionally judicially reviewable grounds. Any imposed restrictions which encroach upon a landowner's property rights should be subject to constitutional review applying the manifestly without reasonable foundation standard. It is therefore considered to be highly unlikely that the board's decision imposing planning restrictions arrived at lawfully and in conformity with the principles of traditional judicial review will be susceptible to constitutional review unless the measures are exceptionally unreasonable. All right? But the question is, a traditional ground will be Wednesbury unreasonable. And if you survive that, I don't see how you can ever survive a constitutional review on the ground as manifestly unreasonable or exceptionally unreasonable. And if assuming Wednesbury unreasonable is the same as exceptionally unreasonable, then what's the difference? What has the CFA done? With that question, and I'm sure many of us have questions for Professor Forsyth, or your own commentaries to make, could I take questions from the floor? Yes.
What? Right, let me answer those questions first of all. I hope you can see the difficulty I had when Pujen was my student. always butting in and telling me I'm wrong. I'm sorry I didn't include the bit about proportionality, because I do think proportionality is again a threat to classical administrative law in many ways. It's very difficult to be against proportionality. I mean, who wants to take a sledgehammer to crack a nut? I certainly don't. And it's proportionality expressed in that way is quite sensible. It's also the case as a matter of law in the United Kingdom, and I think in Hong Kong too. We've got proportionality as a matter of statute law. I mean, not expressly in a statute, but implied by the statute, the Human Rights Act, which says that we have to take account of the decisions of the European Court, the decision of the European Court of Human Rights, and the European Court of Human Rights has adopted the principle of proportionality. So, by hook or by crook, it's there. There's no escaping it. My difficulty with proportionality, which I think must have attracted Pujen when I put it forward, is that it really is incommensurate, in that you are weighing apples against pears in many ways when you are balancing one right against another. Who is to say that my right to privacy is more important than your right to freedom of expression? There's no obvious answer to that question, and I certainly feel very lacking in confidence when called upon to answer questions of that kind. And I'm always struck by how bold the judges are in that they strike balances and so forth and so on, when I think more thoughtful, well, I'm not saying the judges aren't thoughtful, but I think these are actually quite difficult questions. They're incommensurate. And very often, therefore, nothing but a smokescreen to hide a decision being taken on the merits, which, of course, is essential principle of classical administrative law, that administrative law is not about merits, it's about legality. What should the judges do? Well, it's easier for me to say what the judges should do in the UK than it is in Hong Kong. I think in Hong Kong there are other constitutional difficulties, the incomplete democratic mandate of LegCo, the role that China inevitably plays in the government of Hong Kong. These create difficulties in which it makes me particularly cautious to tell Hong Kong judges what they should do. In the United Kingdom, I think the judges have been exercising great power in recent years, and it would be appropriate if they were to restrain the exercise of their power. For the cases I've given, the Evans case and the Cart case, there are several others where I think they've gone too far. I'm particularly worried about Evans because here the Parliament's clear intent is being disregarded, and in a way that is almost a dishonest decision, and that's a worry to me. Cart is worrying because it breaks down the principle of jurisdiction and effectively makes it discretionary. That the judges will decide in their discretion whether a particular judicial review will take place at all. And that's just wrong. So I would ask for more restraint on part of the UK's judiciary. I'm not going to say what Hong Kong judiciary should do.
Can we take further questions? Yes.
Thanks, Professor Forsyth, for your talk tonight. I just want to ask you something that you haven't touched upon. I'm just curious how it fits in with your conception of classical administrative law, and that is the principle of legality. And I want to know if you think the principle of legality, as applied by the English courts, and of course now the Hong Kong courts, we've adopted it, whether you think that is consistent with what you describe as classical administrative law. And the reason why I ask that, of course, is the English courts applied that, as you know, before the Human Rights Act, and in a way it brings in human rights values and ideas into decision-making.
I think the principle of legality is absolutely fundamental. I think it's conceiving of it as the extension of the rule of law. I think it's absolutely essential to classical administrative law. And I spent perhaps too long on classical administrative law, and I should have got into the principle of legality. But the rule of law and its adjunct, the principle of legality, underlies the entire development of classical administrative law. And, of course, it's not so much human rights as civil liberties that the principle of legality protected. But it certainly didn't exclude human rights. And slowly, but prior to the Human Rights Act, slowly but surely, human rights jurisprudence was sneaking into the common law, and I have no difficulty with that in principle. The trouble with human rights is the adjudication of human rights. That so often you are weighing one human right against another, and it's not obvious what the answer is, and there's no easy solution, and that's where the attention needs to be given. But I'm certainly wouldn't like to be understood as not being in support of human rights.
Yes, Riha.
Thanks very much for your talk. I wanted to ask if you could talk a little bit more about why you seem to favor parliamentary supremacy, because it seems to be that your defense of the classical administrative law model sort of is because it promotes parliamentary sovereignty and supremacy. Is that rooted out of a kind of a sort of democratic concern about judges? Is it more about institutional competence? Is it a resource question that sort of parliamentarians just have more time and money to make these difficult decisions? I'm just curious to know more about sort of what the sort of underlying concern is for you.
I'm not a principled defender of parliamentary sovereignty. If you forgive me being slightly personal, I grew up and cut my teeth in the law in South Africa under the apartheid years. I know full well what a sovereign parliament like the South African parliament can do when it is in the grip of undemocratic forces. And I think that is a danger. And it's really the chief case against parliamentary sovereignty, that problem of abuse of the power. If you look at the United Kingdom, my first point is to say it's the law that we have a sovereign parliament. Maybe a good thing, maybe a bad thing, but it's actually firmly established as a matter of legal principle. It has been for some centuries. It may be that we should do away with it. And maybe a good thing if we could do away with it, to avoid the danger of it falling into the hands of undemocratic forces. But the way of doing that would be by political action, not by legal argument, I don't think. Having accepted that it's the law in the United Kingdom, I then take the point that while, like many aspects of the UK Constitution, it is imperfect, it curiously works. In that it could happen that our Parliament fell into undemocratic sources, but it looks reasonably unlikely. And it also means that there is democratic legitimacy, fundamental democratic legitimacy cast over all our acts of Parliament and so forth. So there's a point to be made there. I hope that's some sort of answer to your very good question.
Thank you. If I may just very quickly follow up on that. By doing it through political action, do you mean, for example, the people enacting a written constitution, entrenching fundamental rights? That would be an example of political action.
Yes, that's exactly what I have in mind, that you would have a constitutional convention that would agree upon a written constitution that limited the powers of Parliament. It would presumably, in its Chapter 3, as is usually the case, it's usually Chapter 3, have fundamental rights and all that sort of thing.
Yep. So
and that would then be adopted either by an enactment of the sovereign Parliament, because it would be it wouldn't be able to be gainsaid, or adopted by referendum. I don't think anybody's going to have another referendum in any kind of hurry, but adopted in some way or another. But that's exactly what I have in mind.
I see. So it would be the democratic roots of these fundamental constitutional principles that you're concerned about. But
and we then wouldn't have to worry about the ultra vires doctrine or anything like that. Judicial review would be rooted in the Constitution.
But isn't parliamentary sovereignty itself a creation of the common law? So like in the UK, it's the courts that ultimately created and recognized the principle of parliamentary sovereignty.
No, is the answer to that question.
Is it not?
If you'll forgive me, I mean that is a common question that is asked, and by the answer to it is that Lord Bingham, both in his speech in the Jackson case, I think, and in his subsequently address at King's College in London, where he set out his views on parliamentary sovereignty, said that it's true that we've had parliamentary sovereignty for a long time, but it is not the creation of the judges. It depended upon the acceptance of parliamentary sovereignty by the other branches of government. And it goes back to Hart's theory of law, that the branches of government must all take an internal view of the operation of the legal system. And so, yes, parliamentary sovereignty is a creation. It is a creation from within the British state, that's certainly true. But it is not simply a creation by the judges, depended on the other branches of government. Ultimately, what is at stake here is the final locus, the final place of the final locus of the ultimate decision-making power. Who has the last word? Who has the last word? Is it going to be Parliament? Is it going to be the judges? With us, it is for good or ill, Parliament.
The recent confusion is caused by the intermingling of the executive function as well as the judiciary function of the tribunal. Because in the UK system, normally the judicial function and the investigative power are distinct functions performed by different organizations.
That is a very thoughtful question, and I entirely agree with what you're saying. In the early 2000s in England, we had the Legate report on the Reformation of Tribunals. And this was driven, interestingly enough, by the Human Rights Act, because it was anticipated that Article 6.1 would now apply to many tribunals. And the Legate report completes the judicialization of the tribunal system. And there's, I think, 2007, there was legislation that did this. And it's made the tribunals a part of the judicial system and not part of the administrative system. Now, there's a strong case for saying that tribunals are specialist courts. But at the same time, under the old system, tribunals were far more keyed into policy and so were subject to executive control.
So for that reason, the classical administrative cases, such as Padfield, Anisminic and Wednesbury unreasonableness, are not able to cater for the new development then?
Well, I would have to agree with that. I'm no particular friend of the tribunal system, as it is currently constitutional.
Clement and the gentleman.
Thank you, Professor Forsyth. I wish to follow up on the first case that you mentioned. You questioned the legitimacy of the Supreme Court to override a public interest balancing test conducted by the defending agency. But it seems that public interest test can be found almost not everywhere, but are very frequently found in the UK and other common law legislation. It seems that that kind of mechanism is designed as a power delegation, which means that it seems the Parliament is reluctant to make any substantial decisions. So it creates a mechanism called public interest balancing, so that the agencies could make their own decisions. If those public interest test decisions are not subject to judicial review, would that create a vacuum of exercise of power? Eventually, the executive branch will have unchallenged decision.
Perhaps we take two questions together in the interest of time. The gentleman in blue.
Thank you very much, Professor. And as one of your old students, forgive me for the possible inanity of this question. I speak as a private lawyer, and it is depressing to hear that the trend towards discretion rather than rules is not just confined, as I had thought it was, to the law of tort. And the Supreme Court in the last 10 years seems to be doing the same thing in public law. Do you think there is a natural ebb and flow to the model of administrative law? Do you think in a century from now we will have seen the establishment of the classical model, what looks to be a shift away from it, and then some sort of response back in the other direction? Or do you think once you begin to move away from the classical model, tradition in the UK will take us in one direction and one direction only?
Yes, I've got two completely different questions to deal with. I think the point about the balancing of public interest is well made. And it clearly is the case that both the judicial authorities and the executive authorities can be judges of where the balance lies. The question is who is to have the final word. And in many cases, the final word is properly given to the judicial branch. But in the Evans case, the final word was given to the executive branch. And it's the failure to accept that which is the heart of the criticism of the Evans case. But the point that you make about the balance of public interest is a good one. I think that's all I'll say about that. What does the future hold? I was very cautious about predicting what the future holds. There are, on the Supreme Court at the moment, very strong-minded, thoughtful judges who are loyal to the traditional, to the classical administrative law. And I wouldn't say that they will not prevail. I wouldn't predict that they wouldn't prevail. And that's what I hope would happen. In 10 or 15 years' time, administrative law will doubtless be different. There may have been some reform, procedural reform, but I wouldn't give up all hope for the classical administrative law. And I take some heart from the survival of Wednesbury. A few years ago, and you'd have to come to the lecture that I'm giving to the students next Monday morning to hear more about this. But a few years ago, it was widely assumed that proportionality was going to subsume Wednesbury. But it hasn't happened, and it doesn't look as if it's going to happen. And so that's the classical administrative law coming back.
Why don't I take one last question, if there is one? Yes, the lady.
I'm sorry, after not talking loud enough myself,
Sorry.
I can't hear what you're saying.
Okay, so my question is how to analyze the relationship between Wednesbury own reasonableness and proportionality test, or how does Wednesbury reasonableness evolve into proportionality in common law jurisdiction?
Proportionality is part of English law because of the Human Rights Act. The big question is whether it's also part of the common law. And I think it's moving in that direction. I wouldn't like to think that it has definitely been accepted as a common law principle. But as far back as 1976, I seem to recall, there have been cases like Ex parte Hook where the word proportionality is used. So it is edging into the common law and will exist alongside Wednesbury, I anticipate, but I'm being very cautious about predictions. Thank you.
All right. In view of the flurry of questions we received, it's clear that Professor Forsyth has engendered much discussion and provocative and thoughtful as usual. With that, can we put our hands together and thank Professor Forsyth?